let me then tell you the salient features of the proposed Constitution of the Federal Republic of the Philippines. First, on the national level. Well, the powers of government, legislative, executive, and judicial powers. Since we proposed a federal system, we have two levels of government agencies, governmental power, agencies that exercise governmental powers. The national government and the federated regional government. The easiest image to conjure is the United States of America. You have a federal government headed by President Trump and populated by senators and members of the House of Representatives and the Supreme Court of the U.S. And you have state governments, individual state governments, independent or autonomous as it were from the national government. And the state governments have also legislative, executive, and judicial powers. You even have state Supreme Courts independently of the U.S. Supreme Court. And so on that basis, I would like to present first the legislative department, the proposed legislative department of the federal, that means the national government, in our proposal. So we have a Congress composed of a Senate and a House of Representatives. Our proposal is to have 2 senators from each of the federated regions. The federated regions are the equivalent of the states in the U.S., as it were. Now, our proposal speaks of 18 federated regions all over the country. So we propose the election of 2 senators per region. They are to be elected by the people in the region. This is perhaps borrowed from the U.S., where each state elects 2 senators, a junior and a senior senator from each state. One innovation we included here is that a senator must be holder of a college degree or its equivalent. Natural-born citizen, at least 35 years of age on the day of the election, holder of a college degree or its equivalent, and domiciled in the federated region for not less than 2 years before the elections. The requirement for a college degree generated a lot of debate in the CONCOM itself. Eventually, the requirement for a college degree prevailed. We even asked CHED how many of our people, of the 110 million Filipinos, are college degree holders. And they said that there are quite a number, because we said, can we find at least 24 people, 36 people whom we will bring to the Senate among the college degree holders in the country? And the CHED said, of course, there are millions of college degree holders. You will not lack for choices. And so we have opened ourselves to a very critical challenge that says this proposed constitution is anti-poor because the poor people cannot afford to obtain college degrees. That was farthest from our minds when we approved this. Anyway, it is there now, and we will insist on its approval. We feel that it is necessary for one who will perform legislative functions on the national level to have at least a college degree. I was pushing for must be holders of a low degree. Pero mahirap, I could not get anyone from the 21 other members of the committee to agree with me. But I think it would have been better if, imagine, lawyers lahat ang members ng Senate mo. Then of course, we have the term of office is 4 years. a member of the Senate is eligible for re-election to one other term. The other house in the Congress, National Congress, is the House of Representatives. Ito medyo naging controversial din because our proposal is the House of Representatives shall be composed of not more than 400 members. 60% of them shall be elected as district representatives in the manner in which we elect our present members of the House of Representatives in legislative districts. We have the same criteria for the creation of legislative districts as the 1987 Constitution. 40% are to be elected through a system called proportional representation. The system of proportional representation was the original concept in the 1987 Constitution, which translated into the party list system and which somehow was bastardized by both Congress itself and by the Supreme Court interpreting the party list law. Ito ngayon is, we are looking at purely proportional representation. Although, as a concession to our party list law on the matter of representation of marginalized sectors, we provided that in the first 3 electoral cycles, first 3 elections under this Constitution, 1/2 of the seats allotted for proportional representation shall be allocated to those representing 5 marginalized and underrepresented sectors: labor, peasants, indigenous cultural communities, urban poor, and fisherfolk. The concept was really what the 1986 Constitution wanted when it included party list representation. It was truly based on proportional representation. And so this is what we have tried to restore in this proposed Constitution. Then, ganon na naman, must be a college degree holder. The legislative department and the national government, we said the legislative power is vested in a Congress consisting of the Senate and the House of Representatives. Now, we go down to the federated region level. We have a regional assembly as the legislative branch of the federated regional government. So, the regional assembly crafts regional laws, approves the budget of the region, elects among them a regional and deputy regional governor. Again, even on the federated region level, the requirement of being a college degree holder holds. In the election of the the regional governor and the regional vice governor, we have adopted a parliamentary system, as it were, because it is the regional assembly which will choose from among themselves the regional governor and the regional vice governor. The regional assembly will be composed of the provincial governors, the city mayors, independent cities, and highly urbanized cities, and component cities. They will be each entitled to at least 1 member of the regional assembly. And there will be a corresponding number of regional assembly members chosen through proportional representation. An equivalent number to. In my example here is my own region. I come from Region 8. There are 6 provinces in Region 8. 3 Leyte provinces and 3 Samar provinces. So, automatically, we have 6 governors who will sit in the regional assembly, and there are about 6 or 7 chartered cities. So, 6 plus 7, there will be 13 members who will automatically sit in the regional assembly. Then, the region will elect through proportional representation, voting for political parties, an equivalent number 13 members of the Regional Assembly through proportional representation. This will make the composition of our Regional Assembly in my region 13 times 2, 26 members. And it is this group that will now choose a regional governor and a regional vice governor from among themselves. This is your legislative body in the region. Then, the executive department in the national, you have a president and a vice president still. One innovation we have instituted is that a vote for the president is automatically a vote for the vice president. In fact, we look at the possibility of the ballot containing only one space for president, and because the vote for the president will at the same time be a vote for the vice president. Again, their academic requirement, the academic qualification, college degree holder or its equivalent. In the Federated region, we already mentioned the regional governor and the deputy regional governor who are to be elected by the regional assemblies from among themselves. These are the two officials who will exercise executive powers in the region. The deputy regional governor is vested with an additional duty to preside over the regional assembly, even as he also exercises some executive powers vested in him by the Constitution. Then the judicial branch. Here we have the most changes. In the judicial branch of the national government, we are proposing the creation of 4 constitutional courts. 4 constitutional courts. The Federal Supreme Court, which will basically be the same as, except that a number of jurisdictional powers are taken away from the Supreme Court because they are given to the 3 others. But our Federal Supreme Court will consist of 1 Chief Justice and 8 Associate Justices. The mode of appointment, we still have a JBC of sorts. We call it now the Judicial Appointments and Disciplinary Council. But one of the main functions of this council is to vet applicants for the judiciary. And on the basis of their recommendations, the Chief Justice and 2 Justices of the Supreme Court shall be appointed by the President of the Philippines. 3 justices, associate justices, shall be appointed by the Commission on Appointments, and 3 justices appointed by the Constitutional Court. What was behind the minds of the members of the CONCOM when they adopted this? They said that here you guarantee the participation of all 3 branches of government in the appointment of members of the Supreme Court. The President, the Commission on Appointments representing Congress as it were, and the Constitutional Court representing the judiciary. Then we have the Federal Constitutional Court, also composed of a Chief Justice and 8 Associate Justices. The Federal Constitutional Court is created primarily to rule, to decide cases or controversies involving constitutional questions. In fact, under the proposed Constitution, the Constitutional Court has advisory powers. It may be called by the President or by Congress to give an initial advisory opinion on the constitutionality of a pending bill. And then, of course, all constitutional issues shall eventually be raised to the Constitutional Court. It is going to be vested with the authority to rule on constitutional questions. Then we have the Federal Administrative Court. The Federal Administrative Court has basically appellate jurisdiction over all decisions of all administrative agencies, including decisions of the COMELEC, the Commission on Audit, the Civil Service Commission, the Federal Ombudsman Commission, such other commissions. and other administrative agencies, the Office of the President, and other administrative agencies in government. And then the fourth is the Federal Electoral Court. We have abolished the Senate Electoral Tribunal, the Presidential Electoral Tribunal, the Senate Electoral Tribunal, the House Electoral Tribunal. We have vested exclusive primary jurisdiction over all contests relating to the election, returns, or qualifications of members of Congress, of the President or Vice President, and of the regional governor and the vice governor on the electoral tribunal, on the electoral courts. But the electoral court is composed of a chief justice and 14 associate justices. Why? Because we anticipate many electoral cases that may have to be ruled upon by our electoral court. Notice that we have also proposed an innovation. There is a term of office now for members of the Supreme Court, Constitutional Courts, Administrative Court, and Electoral Court. The term of office is 12 years. Or until he reaches the age of 70, which is still mandatory retirement age. Then we move down to the federated region level. The federated region level may have its own judicial system. Before that, we go to the judicial appointments and disciplinary council. What is the JBC today will be transformed into a bigger body to be composed of all the chief justices of the 4 constitutional courts. Then they are ex officio members. Then the ombudsman, the chairman of the civil service, the chairman of the commission on audit, members chosen by the Senate, 2 members from the Senate, and a member of the Senate and a member of the House of Representatives, then the court administrator, and the Secretary of Justice. These are the ex officio members. We have 4 regular members, 1 representing the Integrated Bar of the Philippines, a law professor designated by the Philippine Association of Law Schools, a retired member of the Federal Supreme Court, and a representative, ito bago ito, a representative designated by the flag officers of the Armed Forces of the Philippines. This was made possible because of the insistence of one of the members of the CONCOM, who is a retired Major General in the Armed Forces of the Philippines. And as I already mentioned, the JADC has the primary function of vetting applicants for the judiciary. And it has also investigatory authority in disciplinary cases. It may investigate complaints against members of the judiciary as well as employees in the judicial branch. And even as the actual power of discipline, the actual power of removal may be vested in the Supreme Court or in any of the 4 constitutional courts. Any disciplinary action by the Supreme Court or any of the 3 other constitutional courts shall be based on recommendations made by the JADC. The judicial branch in the federated region, the regional assembly may create its own regional Supreme Court and its own regional Court of Appeals and regional and trial courts also. So it may have its own judicial organization. Well, in the event, of course, because we foresee that there might arise a number of cases involving jurisdictional problems, well, it's all up to the Federal Supreme Court to resolve all these jurisdictional problems that may arise. Distribution of powers. Government powers are classified into exclusive, shared, and reserved powers. The proposed Constitution has an enumeration of the exclusive powers that are vested in the national or the federal government, and also a list of exclusive powers vested in the regional governments. You will notice that the exclusive powers given to the federal government include matters of national defense, foreign affairs, international trade, customs and tariff, citizenship, immigration, naturalization, national socio-economic planning, monetary policy, including banking and currency, competition and competition regulation bodies. Then, inter-regional infrastructure, postal services, promotion and protection of human rights, basic education, science and technology, regulation and licensing professions. Basic education, for example, is an exclusive power of the federal government. But the matter of education is really a shared power between the federal and the federated regional government, because while basic education is vested in the federal government, the matter of tertiary education and specialized education come within the authority of the federated region. So, look at the powers of the federal government, which include power over social security benefits, federal crimes and justice system, law and order, prosecution of graft and corruption cases, intellectual property, and elections. On the other hand, federated regions are given exclusive authority over socio-economic development planning, the creation of their own sources of revenue, tourism, investment, trade development, economic zones, land use and housing, and they have their own justice system, and then the local government units. Of course, business permits, licenses, municipal waters, culture and language development, sports development, and parks and recreations are within the exclusive authority of the federated region. Now, we have come up with a compromise, as it were. Powers not given to the federal government or to the federated regions and not shared by them are deemed reserved powers, and reserved powers are to be exercised by the federal, the national government. Over the past few days, we have come under a lot of flack, even from members of the cabinet, particularly with respect to the matter of fiscal or financial viability of your federal government and then your federated regional governments. The proposed constitution grants the federated governments 5 possible sources of revenue. First, it has the power to levy and collect all taxes, duties, charges, and other impositions, except those granted to it. Tingnan nyo ang taxing power ng federated regions. Donors tax, documentary stamp tax, estate tax, real property tax, professional tax, etc. All those and fees. This is the first source of revenue of your federated regions. Then, it will be given a share of not less than 50% of all revenue from the following: income taxes, excise taxes, value-added tax, customs duties. Let me just call your attention to a very recent decision of the Supreme Court in the case of Mandanas. Governor Mandanas of Batangas went to the Supreme Court to challenge the manner in which government has been giving local government units the share of the IRA, Internal Revenue Allocation, because the computation made by the national government did not include customs duties. The Supreme Court said everything is included: income taxes, excise taxes, value-added tax, and customs duties. Under the local government code, 40% of this share, 40% of this income of the national government from these taxes shall be allotted to the local governments and partitioned among them, among the 4 local government units to constitute the internal revenue allocation. We are saying that now, under this proposal, we are increasing this share to 50%. Not just 40%, but 50% will be given to the federated regions, and therefore to all the local government units within the region. Then there is an equalization fund that is established here. The equalization fund is supposed to be not less than 3% of the national budget. It is to be administered by the Federal Intergovernmental Commission, and the fund will be used to help support federated regional governments that need financial assistance. Then, one of the major complaints of local government units is the fact that taxes paid for utilization, development, extraction of mineral resources in the various provinces go to where the taxes are being paid, not to the places where the resources are found. This is the major complaint of Baguio and the Cordilleras. They have so many mines there, and the mining companies pay their taxes in Makati, and very little of these taxes flow to the Cordilleras. In this proposed constitution, we are saying that the federated region where these resources are found shall be entitled to at least 50% of the net revenues generated from the development exploitation of these resources. And then, of course, Congress may, by law, grant additional financial assistance to the federated regions. I saw on television a program where the Secretary of Finance was being interviewed, and he expressed his reservations about this proposed constitution because he said that there are problems. Problems will arise on where to get the finances. For example, he mentioned we would like to make sure first where to get the financing or the funding. For example, he said, where are we going to get the money that we will pay, that we will spend for the armed forces of the Philippines? I was puzzled because there is going to be no change at all in the matter of the armed forces of the Philippines. For example, the armed forces will still be with the national federal government, and there will be little changes even in the structure of the military. How does the present government finance the military? That will be the same. That will be the same revenue that will be used for funding or maintaining the military, even under a federal government. Anyway, I have a table that I would have wanted to flash on screen, but we don't have enough time right now. I am going to leave these copies on the proposed sharing of revenue between the federal government and the regional governments.